Welcome to the Civil Litigation Housing podcast here at Adam Bernard Solicitors, where we discuss important legal issues surrounding tenancy, housing, and landlord and tenant relationships. We are your hosts, Fatma and Tosin, and today we're kicking off our series with a crucial topic for landlords, the do's and don'ts regarding tenancy agreements. So, whether you're a new landlord or have been renting properties for years, understanding the intricacies of tenancy agreements is vital. These agreements are not just formalities, as you're aware, Susan, but legally binding documents that protect both you and your tenants. And today, we'll explore what to include in these agreements, common mistakes to avoid, and your legal obligations as a landlord. And I'll be now handing it over to Susan, a solicitor in our housing team, to discuss some pointers regarding the key components of a tenancy agreement.
Thank you, Fatima, for that introduction.
Yeah.
We'll start by the understanding the key components of the tenancy agreement. Now, a comprehensive tenancy agreement should have several clauses. I think the first thing is it must contain the names of all the tenants. It should also have the property details as well. And you want to also make sure that the terms, including the amount of the rent, should be included in that contract. And it would be good to also have the landlord and tenant's obligations to be specifically included in the contract. Yeah? And then we can now move on to common mistakes that landlords make when they are dealing with tenants.
And how to avoid them.
Basically. So sometimes we get landlords using generic language in the generic templates in the agreement. So they just get like documents from like maybe a random website.
Or they use ChatGPT as well.
ChatGPT, yes, exactly. Yeah. And we don't advise this. This is a common mistake that landlords usually make, and what usually happens is that they miss some, because obviously things like ChatGPT wouldn't give you everything.
Not really accurate legislation as well.
Not accurate legislation, yeah. And the second mistake is obviously, like I said, omitting essential clauses. And we obviously sometimes tenancies could last 2-3 years, and I would always advise for landlords to update their agreements every year. So we can now then move on to the legal obligations and rights of landlords. Landlords must ensure that the property is kept in a safe condition.
Ensuring there's no disrepairs.
No disrepairs, because that's usually the key obligation for a landlord. You have to provide habitable property for your tenants. You should also make sure that you're conducting periodic inspections to make sure that the property is always kept safe for your tenant. In terms of the documents that you need to provide, so you need to ensure that you provide your EPC, gas certificates. So every year you want to make sure that you're renewing your gas certificates. For the EPC, it lasts 10 years, so you want to make sure that every 10 years you're renewing your EPC.
This is essential for landlords, because what you have is when there's typically landlord and tenant disputes,
yes,
tenants usually bring up that, oh, my landlord's not providing me with an EPC certificate or a gas record. And that poses to be an issue. It
poses to be an issue, definitely, because when you get to eviction, let's say a landlord is willing to evict a tenant, it causes problems at that stage, because if you haven't provided an EPC gas records, it would basically invalidate any notice you issue at that point. And then we can move on to obligations of tenants. Right. The tenants must make sure that they keep the condition of the property in good shape at all times. Things like antisocial behavior should also be avoided. And also the main thing, which is making sure that they pay their rent on time.
No rent arrears.
No rent arrears, please.
Do you want to talk about how rent arrears is supposed to be an issue for not only the landlords when it just comes to them seeking eviction notices or other things to do with the actual dispute itself, but how it affects the landlord's personal life as well. For instance, we have one client and the landlord then had issues paying off their mortgages and stuff because they weren't given I mean, the rent that they were due by their tenants? How is that supposed to be an issue?
I think it's very good for a tenant to be aware that when they default in paying rent, it affects the landlord in the sense that they're not able to pay up their mortgage. Landlords, obviously, the way they've purchased the house, they have a mortgage arrangement, and every month, what they've done is the rent that you're paying is the money that they have to pay towards their mortgage. So any default in that aspect will obviously affect the landlord's mortgage, and eventually it could even lead to the mortgagee repossessing the
property.
Yes.
I thought that would have been just a key point to mention for the landlords, because typically in landlord-tenant disputes, we have a lot of people sympathising with tenants and their stories, but landlords do have their own personal issues, and they do get affected heavily by tenants in certain areas.
I agree.
So
we'll be moving on to handling security deposits properly. So as landlords, you have the obligation to collect deposits and register that deposit with the scheme within 30 days of collection. If you fail to protect that deposit, then it could also affect several things, such as eviction later on, and then it would also invalidate any Section 21 notice that you intend to issue later on. Yes. So as a landlord, you must make sure that you're protecting the deposit within 30 days.
yes, did we not have a client that dealt with, they were the landlords themselves, but they failed to secure the deposit? It was a late securing of the deposit.
It was a late, yeah.
Yeah. How did that supposed to be an issue for them, if you recall?
So usually if you protect the deposit late, so let's say after 30 days, that's a big problem for you already, because you've missed the window, and then sometimes landlords are running helter-skelter saying, I failed to guide. The question is, they want to know whether or not the late deposits protection would still protect them. No, it doesn't protect them. Once you've missed the window, then obviously you fall at risk of being liable for up to 3 times the deposit and the return of the deposit.
Thought that'd be a clear point to mention for our landlords, because they're faced with these undue costs that they don't realise just by making the smallest mistake of not protecting the security deposit. Now they owe a tenant 3 times the deposit that they once provided.
And I could even just mention quickly that with first-time landlords, and they call, like, we have clients that say, well, I'm just first-time landlord, like, I don't think I should be liable. No, it doesn't. Even if you're a first-time landlord, the legislation still states you have to protect within 30 days, and if you miss that window, I mean, that's
Have we covered enforcing these terms?
Yeah, so in terms of enforcing, so can you advise me?
I mean, what would be the rules regarding property use and behaviour? Like, how do these terms sort of help that?
So do you mean rules about the use of property?
Yeah, within the lease.
Yes. So the lease is what guides both the landlord and tenant. If you, as a tenant, I believe that if you're presented with a lease agreement, you should ensure that you're reading every single detail of that agreement, because you have the chance to go back to your landlord and sort of renegotiate. If there's anything you don't understand, if there's anything you don't want on that lease, and you can then speak to your landlord about it.
Precisely. Sorry to
No,
cut you
go
off.
ahead,
There are
it's
landlords
fine.
that typically do exhibit certain clauses in agreements, and you'll have tenants then show up afterwards saying that there was no such thing prior to our level agreement. So in that instance, what would you recommend to landlords?
So to landlords,
Yes.
in that instance, I would say that for landlords, the thing is, landlords would always give you an agreement. If you sign it, I mean, there's an assumption that you've consented to the terms of that agreement. So in terms of for landlords, I would say that if they make sure that they go through the agreement with a solicitor first, make sure that they
seek legal advice.
Seek legal advice and make sure that they've got everything right. And
no undue unfair clauses
you
within
can't
that.
use undue unfair clauses, and they will not be enforceable.
So as we now gear towards the end of our podcast, let us cover our last segment of today's discussion, and that will be tips for creating a fair and comprehensive agreement.
Okay, so we need to first discuss clarity. Clarity is key. Make sure you avoid legal jargon. Make sure that you're as clear as possible. The law doesn't accept ambiguity. You should also make sure that you include a dispute resolution clause. So what laws are applicable to the contract, and consider including a clause outlining the disputes, how disputes will be handled. If you want arbitration first before going to court or mediation, you should make sure that you also include that in the contract.
Because what do we always aim to do? We always aim to stay out of court.
Yes.
So that is
the first thing, yes.
That wraps up our first episode on the do's and don'ts regarding tenancy agreements. Remember, a well-drafted agreement is the foundation of a smooth flowing landlord-tenant relationship. Stay tuned for our next episode where we will dive into the tenants' rights and responsibilities. And this has been Civil Litigation Housing Podcast at Adam Solicitors. Thank you for listening.